Library. We are here for this law day at the Portland Public Library because libraries are at the heart of our communities and justice is at the heart of our democracy. I am pleased to present today information to interested members of the public regarding unemployment compensation appeals. I will talk about how the process works. I will also talk a bit about what resources may be available to individuals who are appealing from a decision that denied them unemployment compensation. And to the extent we have questions from people that are here with me today, I'm happy to respond to those as well. I thought I would at first begin with an overview of how the process works, essentially from start to finish, and then after that point, focus on the issues that are typically involved in an unemployment compensation appeal. Initially, after an individual is let go from his or her job, whether it's involuntary or it may be voluntary, they go and apply for unemployment compensation. This can be done online through the Department of Labor website. I'm sure there are people here with me today that can point to other places where you might apply, but once the individual has applied for unemployment compensation, then he or she will hear from a representative from the Maine Department of Labor. Their title is deputy, if you will, and the deputy's job is to interview the individual who is seeking unemployment compensation, as well as the employer, to determine if that individual is entitled to receive unemployment compensation benefits. At that point in time, there are no attorneys involved. There are no formal hearings. It is just a matter of the deputy contacting the employee and the employer to make an initial determination as to whether that employee is entitled to unemployment compensation. I have in front of me essentially a form that the deputy would complete as he or she is interviewing the necessary parties. And the employee will also get a notice in the mail as to when this interview will occur, and obviously the employee needs to make sure that he or she is available to speak with the deputy. And the deputy will ask questions about what the employee did for this particular job, why the employee believes that he or she was let go, what extenuating circumstances there may be that the employee thinks is important for the deputy to understand, and then the same process will occur with an employer representative. Once the deputy is engaged in this fact-finding mission, a decision will then be issued, either concluding that the employee is entitled to benefits or concluding the opposite, that the employee is not entitled to benefits. Typically, the reasons why an employee might be deemed as disqualified, i.e. not eligible for benefits, typically the two main reasons are that the employee voluntarily resigned from his or her position, i.e. The employee refused a suitable job with the current employer or just quit for reasons unrelated to the job. The other typical reason why an employee might be deemed ineligible for benefits is if the deputy concludes that the employee engaged in misconduct. And we'll talk a bit more about what the term misconduct means in the unemployment statute. Continuing the process, if the employee is ruled ineligible for benefits by the deputy, he or she will get a decision in the mail, usually a 2 or 3 page decision, which explains why benefits are being denied. That decision will also instruct the employee that he has or she has 15 days from the date the decision is mailed to file an appeal. Similarly, if the decision is that the employee is entitled to benefits, obviously the employee has no need to appeal because he or she won, but the employer is facing the same deadline. The employer has 15 days to file an appeal. It is very important, if you're an employee and you were denied benefits, and you believe that decision was wrong, or you want to have another chance at a hearing, it is very important not only that you appeal on time within that 15-day deadline, but you document how you made the appeal. You can fax in a letter to the Department of Labor and their instructions on your decision as to how to go about doing this. You can fax in your appeal, you can send it in by mail, you can have it hand-delivered. However you go about doing this, you should make sure that you have documentation of how you did the appeal. So in other words, you should keep a copy of the letter that you send where you request an appeal. If you fax it, you should keep a record of that fax. If you send it by regular mail, it's not a bad idea to go to the post office, to the desk at the post office in your hometown, and ask for a certificate from the clerk that says you mailed it out. That can be done even for just a regular first-class mailing. That way, in the unlikely event that your appeal got lost in the shuffle, you would have record evidence that you filed your appeal on time. Once you have appealed the deputy's decision, you will receive in the mail a notice of hearing from the Department of Labor. And the notice of hearing will tell you that you are going to have a hearing scheduled before an administrative hearing officer, and it will tell you the date and the time and the location. Many of the hearings, in fact, most of these unemployment compensation appeal hearings are conducted by telephone. Sometimes they are done in person, but as a general rule, at least my experience has been that the majority of these appeals are heard telephonically. So if you are going to be handling this on your own, you don't need to travel to Portland or Augusta or Lewiston or wherever the office might be that would hear your appeal. It can be done from your home phone or your cell phone. In the notice of the hearing that you get in the mail, it will say what phone number the administrative hearing officer plans to call you at, and likewise for the employer. And if for any reason you need to change that, if your phone number has been changed or disconnected, or if you obtain counsel, your lawyer will notify the department that the phone that they should call at might be at the lawyer's office. But you want to make sure you stay in touch with the Department of Labor to make sure that they know how to reach you when it comes time for your unemployment compensation appeal. Now, we'll talk a bit more about how the appeal hearing actually works, but this is essentially a brand new hearing. The hearing officer is going to take evidence similar to a trial, but the rules of evidence don't necessarily apply, and it's a bit less formal than a courtroom. But the hearing officer will hear the facts from the employee, usually from an employer representative, and will make a decision based on the evidence before that hearing officer. So it's not as if the hearing officer is going to look at the deputy decision that you didn't like and rely on that in any way. It's essentially a brand new hearing or trial, if you will, for your argument that you're entitled to benefits. To continue the process, and I will get back to how the appeal hearing works in a minute, but to continue the process, at the hearing officer will take evidence, and then he or she will render a written decision, and I believe they're under a time deadline to issue the decision. It's generally within a few weeks, and I apologize, I don't know the exact deadline if there is one. But that's you will get a decision in the mail. If you have an attorney, the attorney will get a copy as well. And if you don't like that decision, if the hearing officer concluded that you're not entitled to benefits, you do have the right then to appeal the decision to a 3-member commission. The commission has discretion to just review the record and either affirm or reverse the decision, or the commission can conduct a brand new hearing or can ask that the parties submit evidence on a particular issue. Once the commission issues a decision, so that is the third opportunity for you to get a decision. If you don't like that decision, you could appeal to the main superior court, and then it's in a judge's hand. So let me back up now to the actual unemployment compensation appeal. This is where most people, if you're denied benefits in that initial deputy decision, most people have questions about how to prepare for the unemployment appeal hearing. And as I said before, it is a brand new hearing. The hearing officer is not bound by the decision of the deputy, but the hearing officer will include the deputy's decision in the record, really as a function of having in the record how the parties got to the point of having a hearing. The hearing officer will have the deputy's decision as well as the notice, which tells the parties what issues are in play for that particular hearing. So how does an employee who's been denied benefits prepare for this hearing? There are a couple of things that I would recommend doing in almost every case. One is for the employee to request a copy of his or her personnel file. Under Title 26 of the Maine Revised Statutes, Section 631, an employee has a right to demand and obtain access to his or her personnel file at his or her place of employment. So I'm holding in my hands a letter that I typically send on behalf of my clients to the employer demanding a copy of the personnel file. The reason I request that and the reason why I encourage employees to request the personnel file is there are often very helpful documents in that file that might persuade a hearing officer that the employee's version of events is the more credible version. For example, an employee might testify that he or she never had any